Good afternoon, everyone. Thank you for being here. I gather this is usually a very sort of small and intimate affair so that we can engage with the ideas in the paper. And so I won't sort of spend too much time introducing Alon Harel, who is currently a professor of law at the Hebrew University Law Faculty. And currently he is visiting the Wissenschaftskollegen in Berlin. He is writing a book on the nature of public authority. So he has visited many places across the world. If you follow him on Facebook, he has very exciting travel.
Oh, we are friends on...
Yeah, we are Facebook friends. See? We're real friends. We're actually Facebook friends. But in addition, he is also a highly dynamic intellectual in Israel. Among his many sort of pursuits, he also periodically sues the state of Israel for various constitutional breaches. So there's actually one case you were telling me, which you have to study when you study administrative law in Israel, which has his name on it. Was it Harel versus?
Harel versus the Knesset of Israel, the Jewish Agency, and the State of Israel.
See, things to aspire to, life goals. But anyway, without further ado, so what Alon will be doing is present his paper, speak to us about his paper for about 45 minutes.
Okay. I hope.
One hopes. And then we will sort of open the floor for questions and discussions.
Yeah, thank you very much for inviting me. I'm very happy to be here. It's actually my third time here. And I'm going to share some thoughts about questions concerning the nature of law and authority. I've never written on this before, but given the fact that I'm now engaged in the issue of authority, the sources of the authority, liberal authority. Jacqueline had mentioned a book. I probably wrote you that I'm writing this. I'm not sure anymore, but
okay.
That I've been trying to write. So this actually connects issues concerning authority and questions concerning the nature of law, positivism, and so on and so on. So when you look at the philosophical study of law, you see that it's going around basically two questions. One question is what law is, which I always find very boring, I must say, because to a large extent it's a definitional matter, semantic matter. The second is the question concerning the normativity of law, why law is, or whether and why, if it does, law gives us reasons for action. But this paper differs from the traditional way of looking at it, I hope, in a quite dramatic way. The two main theories about the normativity of law, one of them is tied up to positivism, the other tied up to natural law theories, basically claim that to the extent that the law provides reasons for action, the reasons for actions are a byproduct of the content of law. So they focus on the question of whether the content of the law makes it act more in accordance with justice. So you have to look at the content of law and see whether it induces us to act on the basis of justice or reason more generally. By contrast, this paper, by the way, which I have to mention, I wrote it with Avichai Dorfman, who is a professor at Tel Aviv University. By contrast, this paper argues that law normativity is not a matter of content. Rather, we should look at the question of status or standing or legitimacy more generally. Standing requires a relation between lawmakers and officials, such that the former, the lawmakers, represent the latter, represent the people. Hence, the key to the understanding of the normativity of law is that of understanding what counts as a public institution by which I mean an institution that represents the people who are governed by it. Consequently, what this paper cares about is issue of legitimacy rather than the issue of the content of the law. So we ask what law is legitimate. And law is legitimate when the law can claim or claims to represent us. Legitimacy is defined here as a capacity to speak in the name of all. And to speak in the name of all is a foundational normative underpinning of the legal system. So given certain conditions, which I'm going to specify very generally in this paper, law is legitimate when it speaks in the name of all, and it's legitimacy rather than justness that explains why law is normatively important. Here you can ask, I think, a very plausible question. And the very plausible question is, how can it be that the content of the law, or how can it be that law can have desirable features unless its content is just? To account for this, this paper takes quite, I would say, Kantian approach in this respect. And it basically says that, in the first place, law has to, private individuals are equal and free, and therefore, private persons may not occupy the standing that is required to give judgment legal effect or authority. And it is because public institutions can claim, ideally at least, that they represent us, and I speak a lot about representation here, that they can claim to be legitimate. I've written in the past about public officials, and I asked the question of what makes public officials relevant normatively. In this paper, I'm more interested, and that's an important thing, in legislature, which I regard also as a type of public officials. But in the former papers, I asked what makes the position of the public officials relevant. And here I ask what makes the position of the legislatures relevant. I want to make two observations before I try to develop the main theme. First of all, the principle that I'm advocating here is basically a principle in political theory. And you can ask, what does this have to do with the nature of law? Why do I actually advance this and tie it up? Because after all, the question is that law is legitimate only if it represents the people, only if it speaks in our name, and so on and so on. But you can ask, why does this have to do with the nature of the law? Now, to be frank, I don't care that much about the nature of the law, but I do think that, unlike questions of justice concerning the content of the law, which characterizes most of the current theory, the principle that we invoke in this paper resonates with the idea of law. And I think you can find hints in Hart and in some positivist theories that they care about legitimacy. I don't think Hart was aware of it. H.L.A. Hart, the philosopher, I don't think he was aware of it. It wasn't his main thing, but I think his theory can be reinterpreted in light of what we are saying in this paper, and it makes much more sense if we look at it in this way. So, so basically, so far I made a dichotomy between content on the one hand and legitimacy in the other. So this was the first point I wanted to clarify. Second, and this is a very important point, in claiming that the law has to represent us, to speak in our name, I don't deny that its content is important. Of course its content is important. The content of the law is important. But I do think that legitimacy is also important, and I think the nature of the law, questions concerning what law is, are tied up more with the legitimacy of the law than with the content of the law. What I'm going to do now is the following stages. First of all, I present two reductionist arguments concerning the law normativity, both of which rely on the content of the law. I then criticize these views, and last I argue that the normative force of law does not rest on the convergence between action and reason, as the people who advocate the traditional theorists argue, but rather on its publicness, in particular on the possibility of speaking in our name, in the name of citizens. I also argue that to understand what it means to speak in the name of citizens, we have to speak about representation. Let me start with the two traditional views. One view I call it add-on, but it's basically positivism, and you will understand in a minute why I call it add-on. The add-on position, law can give reasons for action because and insofar as it is instrumentally valuable to people's practical affairs in the following sense. It sets out rule and institution that help people comply with extra legal demand of right reason. Or as John Gardner, who just passed away, regrettably, has put it, drawing on the service conception of authority, the main point of all law is to help people do what they ought to be doing anyway, quite apart from the law. The success of the law in doing it is, of course, hinges on its content. The law has to identify what we ought to do, and then and induce us to do it. This is a very influential theory of authority, the theory of Joseph Rice. The competing reductionist view, the constitutive conception concerning law and normativity, I think it's more identified with the natural law theory. And Dworkin is one, I think, very clear example. Dworkin follows a long-standing tradition of natural law thinking, under which law is a component, is constitutive of morality. This is also the view that is taken by Immanuel Kant. Immanuel Kant thinks that without law there is no full-fledged morality. It's a part of morality. On this tradition, you cannot speak about political morality separately from the law, because the law represents public reason, blah, 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 is an integrative part of morality. So, on this conception, reason, unlike Joseph Rice's view, reason cannot be specified apart from the law. The source of the failure of both theories, this is the main argument of the first part of this paper, is in viewing the law normativity as a question concerning legal content, namely the degree to which it converges with justice, with reason. The failure motivates us to look for the normativity of law elsewhere, namely in the concept of standing. Standing is not a matter of what the content of the law, but of whose pronouns can count as law. To see why, think about a simple case of mala in se, a moral duty against punching people, innocent people in their face. Yeah, we all think that that's not a good idea, I think. Farser assumed that there is no disagreement concerning the morality of this duty, the just way to effectively enforce this duty, and so on and so on. The legal system grants Kevin, call him Kevin, I could call him Andrew, a private person the power to determine what legal duties we have and how to enforce them. The Kevin decides that the society must have a legal duty against punching people in the face, and arguably, you could say, there is no reason to resist this because we all agree about the content of this. That said, we argue everybody, or one could argue everyone is entitled to resist this simply because it is made by Kevin. The underlying intuition rests on the conviction that all individuals are born equal and free, and therefore no private person can occupy a position of deciding what moral or reason-based prescription are binding upon others. Given that the law is binding on all of us, Kevin cannot legitimately dictate what the law is. make, I think, a quite good argument against this and argue, look, this is not about Kevin, this is about us. We think, let's say we accept that Kevin is better able to identify what reason requires. And therefore, when we do what Kevin does, we are more likely to act on reason. And therefore, there is no reason to resist the claim of Kevin, because if I act on my own judgment, I will make more mistakes, and I will or act unjustly, and so on and so on. This seems like a compelling response, but I think it rests on a hidden premise that I wish to challenge here. While we are obliged to comply with our duties, there doesn't seem to be a duty to act in a way which maximizes the convergence of our actions with our duties. Sounds a little bit complicated, but I'll explain it in a moment. The prospect of having a duty may sometimes imply also a duty to invest in a reasonable effort in identifying what our duties are. So if, for instance, I promise something to somebody, and then there is some conflicting obligation, you know, I have to explore which obligation maybe is more important or more valuable, and so on, and act in accordance with this. So I do have a duty to examine. But it doesn't follow that we have a duty to use a particular mechanism to identify what our duties are. And I'll give you an example. John has a John has a self-biased, self-serving view concerning the binding force of a promise he makes. John is disposed, therefore, to infringe his promises when they are inconvenient. John's friend Susan is a fair-minded person, and she can evaluate promises, duties, and so on and so on. And she makes better and more accurate judgments about promises than John. While John has a duty to honor his promises, and he violates his duty whenever he fails to honor them, it doesn't follow that he has a duty to consult Susan. So when he violates a promise towards me because he thinks wrongly that this promise was overridden by other considerations, John, I couldn't complain, John, you should have consulted Susan. It's not his duty to maximize a convergence between what he does and to maximize the convergence between what he does and reason. It's on his duty not to violate his promises. It's not his duty to consult Susan. What is missing in this description is some notion of publicness. Kevin's authority depends on the ability to transcend his own status as person, in particular, and to become the voice of us all. This will be the main argument that I'm going to develop in the next part. Kevin identity is a private identity, and it is his private identity that is responsible for the fact that he lacks authority. What accounts for Kevin in omnipotence is the fact that his decision to impose a duty is fundamentally his decision rather than our decision. The person substitute is exercise of judgment with a judgment that could be made in the name of those subject to the duty. Further, his judgment precludes these people from identifying this duty with a judgment made in their own name. The case of Kevin, I think, shows that it's not necessarily the content of the legal prescription, but rather the very identification of Kevin prescription as legal that explains why resisting his authority is appropriate. It is a fact that these prescriptions are Kevin's rather than ours. I want to provide here a historical example which I learned only recently, which I found extremely interesting. There is a guy, a historian, Stephen, it's actually cited in my paper, I don't remember now his name. And he wrote a book about all sorts of adventurers in the
Stephen Press.
Stephen Press, yes. And he
No,
wrote
28.
he wrote a book about adventurers in the 19th century. His claim was quite amazing. In the 19th century, people like us, middle class people, maybe more adventurous than academics, I think, overall. Academics are not particularly adventurous, but maybe people who are here in the stock market or something, instead of being in the stock market, would go and create what they claim to be a state in some parts of Asia or Africa, and they claim to be a state. Now, admittedly, these guys wanted money, so presumably they were not the best leaders of the world, but let's say some of them were good-hearted people, and they just controlled certain sections of the population and claimed obedience. Now, why are we so obsessed about resisting this? We are obsessed about resisting it because they didn't know the people there. They had no clue what they had no clue what their views. They couldn't represent them. They could have been good rulers in some kind of abstract way, but they weren't legitimate rulers because they didn't come from the community in some ways. It is evident that what the problem with these guys is the problem of representation. Colloquially speaking, the complaint against Kevin would go along the line, who are you to decide what the law is, rather than what the content of the law is. Hence, the explanation of law normativity needs to address the question of who Kevin is, rather than whether what is said converges with reason or justice. Public office extend the agency, this would be the argument, or identity of the law subject, in that it enables them to do things as a collective entity. It makes collective undertaking possible. What I try to do so far is to make two points. Negatively, the difference that law makes in the space of reason is not one of content. Affirmatively, we need some concept of representation, some concept of doing something that... the question is whether we can find such a way. Whether we can find a way to explain the legislature position in terms of voicing our concerns as citizens, or speaking in our name. That's what I did with respect to public officials in my book, Why Law Matters, in some articles, and that's what I want to do here with respect to the legislature. I argue that there are two features that characterize the legislature. One I call detachment. Detachment from the private self of the individual, and the other is representation. Detachment is a negative requirement. It denotes the fact that the representative does not speak as a person, as a particular person. He speaks as not in his name. Representation means that he speaks in our name. So detachment will refer to decisions that are not made in the name of any particular individual, even not the person who makes the decision. This form of detachment is essential to law normativity. It is essential to have the standing to speak as a legislator rather than as a particular member of the parliament. This is because the absence of detachment generates the egalitarian difficulty of private person purporting to become superior to others. Detachment is necessary but not sufficient. And the more complicated feature of detachment, the more complicated characteristic is a characteristic of representation. Deciding in our name depends on establishing a sufficiently tight differential relation between the decision maker and the people on whom the decision purport to be binding. We must find a connection between the legislature and the people, such that in a way we can conceptualize the legislature as deferring to the people. This is the challenge. This is a challenge that, by the way, Kant has provided us but never addressed for reasons I'm not going to get into here. But anyhow. So what does it mean to represent people? And here I want to make something, to say something about representation at a very, very high level of abstraction. In other words, I'm not defending here a particular view of representation. In fact, some views of representation that I present here, I actually think are quite horrible and morally wrong, and so on and so on. I'm only presenting the ways we can conceptualize, ways in which traditionally the concept of representation could be conceptualized. And I distinguish between two forms of representation, as you saw in the paper. One is called the agency conception, and the other is called the essentialist conception. The object of deference, in the case of agency, concerns what people want, what they prefer, what they judge to be correct, questions of this type. The object of this, the legislator represents us when it decides in the way we would have decided, and maybe we would have decided under some kind of ideal conditions. So I think that Rawlsian theory could somehow be classified as in this way. So we have to ask, or the legislator has to ask what we want or what we judge to be true, and so on and so on. And it pushes it, it sounds as if this is a very requirement of majoritarianism, but I think it should be understood in a weaker terms, in some kind of terms of correlation. Or I have some views about this that are not presented in the paper, and I could get into them in the discussion. The question of what we want is obviously sometimes very complicated. I just mentioned one complication that I wrote about. Sometimes, take James. Let's say James is very much in favor of capital punishment. He's dying to have capital punishment. But he dies to have capital punishment because he believes capital punishment deters people from committing crime. And let's say I'm the legislator and I represent James. And I know, as a matter of fact, that capital punishment does not deter, because I read all the research. It's not clear that to do what I want is to vote for capital punishment, because James wants capital punishment, or to vote against capital punishment, because James wants capital punishment only on the condition that capital punishment deters, and he's wrong in believing that capital punishment deters. So the question of what representation in this sense, in the agency sense, is very complicated. I could discuss this in the discussion. The second representation view that I discussed in the paper is what I call the essentialist representation. And those are theories that relate to who I am, not necessarily what I want, but who I am. So for instance, we often say that we should have women representing women, not necessarily, or not only, or not because they have similar views, but because in some way they represent the essence of the people who are being represented. I will deal with it in a greater detail. So we don't develop here, as I said, we don't develop here a normative theory or institutional account of what it means to represent. We only provide a survey of views that are naturally related or perceived or can be conceptualized as forms of representations. Okay, so agency-based theories of representation maintain that representatives conform in their preferences or judgment to those of the represented. It requires the legislation take such views as their inputs in deciding what prescription to call into law. Now, there can be a lot of principles. Majoritarianism is one, but we can adopt weaker theories and weaker connections or correlations between the two. The underlying intuition behind the idea of the agency is one of attribution. The enacted law is not merely the private assertion of power on the part of the legislator or any other person. Rather, the enacted law must be attributable to the society in general. So the requirement that a legislator take into consideration or be constrained by the preferences and judgments seems to leave a lot of leeway to legislator to do a lot of things, but they can only be legitimate, the law can only be legitimate if it represents the people. What are the essential theories of representation? Here there are, in my view, there are quite a few, and they are very different than each other, and I want you to do a survey of those, very quick survey of those. First of all, there are theories that rely a lot on custom and practices in the society. So it is not the preference or judgment of the represented count, but certain objective features of the representative. Jeremy Waldron spoke about this when he said that identify a practice of lawmaking exercised in the by the medieval English kings. The basic thought underlying that practice of making customary law, or the law of the land, is that, and I cite from his book, law is originally something held in common, something essentially ours, something indeed which only exists in the extent that it is embedded and part of our shared form of life. So it's not what we want or prefer. We may prefer something else, but the fact that we live this way is already the fact that we live in this way suggests that it's something that is from us, and the representatives, our representatives, actually do what we are. In a way, they reflect who we are, and the way to identify who we are is to act in accordance with the customs of the society. We agree with this description. There is underappreciated similarity between legislative assembly on the one hand and custom on the other. In both cases, the representative is not the true originator of the decision, but rather the one who voices decisions made by others, by the representative. The modern institution of legislative assembly embodies an agency-based view of representation. By contrast, custom can be conceived as grounded not in the agency of the constituent, but rather in certain natural features of the represented that are reflected in their practices. The object of deference is not the product of deliberation or manifestation of preferences, but something that is revealed by looking at the practices. Another variation on the essentialist representation theme can be found in what is labeled after Pitkin a descriptive representation. That's quite, I think that a lot of political scientists have written a lot, and I cite here from her, representing is not acting with authority. Rather, it depends on the representative characteristic, on what he or she like, on being something rather than doing something. The representative does not act for others. He stands for them by virtue of a correspondence or connection between them, a resemblance or reflection. In political terms, what seems important is less what the legislator does than how it is composed. There are many variants of this, and I'm not going to get into them, but partly because they're not interesting in my view, but there are clearly forms of representation, essentialist representation. The decisions made by the representative are ones that are determined not by the representative, by some kind of natural features. They are women, they are blacks, they belong to us. In this respect, they represent us. The last one, which is one that you can guess I don't like very much, but I can't deny that this is a very prominent view of representation that falls into this category of essentialist representation, can be found in the context of nationalist states with typically illiberal regimes. The Hungarian constitution, for instance, includes various provisions which impose duties on its officials, and I cite, to preserve the intellectual and spiritual unity of our nation, to be committed to engage in promoting and safeguarding our heritage, our unique language, Hungarian culture, the languages and cultures of nationalities living in Hungary. This language refers to the constitutional responsibility of public officials to replicate in their decisions essentially these features of the Hungarian people. I must say in Israel they passed also a similar law, basic law, a few years ago. It is not the judgments of the representative or the preferences in the agency-based conception of representation. It is something that is essential about the represented, their being Hungarians or their being Jews in the case of Israel. The standing to make laws in our name depends, therefore, on a sufficiently tight connection between the decision maker and those to whom the decision maker is to whom the decision is addressed. This connection takes the form of deference, which hinges on representation. What we did in this paper is distinguish between two different frameworks of political representation, each of which aims to provide an account of the deference that should exist in order to be legitimate between the representative and the represented. The agency-based reflect more liberal sentiments, while the essentialists underlie nationalist, sometimes anti-liberal, not necessarily, but sometimes anti-liberal sentiments. Since, again, my ambition here is only to explain the distinctive significance of representation for law normativity, I do not address here which form of representation is correct and whether there is one that is correct. I don't do this here. I just identify this. The proposed conception of law normativity deviates radically from other views. Our rejection of the traditional view rests ultimately on a commitment to basic equality and freedom. With respect to the former, the equal status of us all precludes the possibility of identifying the normativity of law with reason as such, a view which would require us to grant legal authority to the person or class of persons who is most capable of identifying what reason dictates. Our conceptions of law normativity also rest on freedom. The question of whether we are free persons hinges not only on whether we are constrained in certain ways, but also on who can constrain us. It is us that can constrain us. If the entity that does the constraining acts in our name, the constraints need not infringe on our freedom. Law can make a difference in the space of reason when it rests not on what reason dictates, but rather on decisions that can be attributed to all of us. What renders this possible is the emergence of public officials, whose value lies in the fact that they are public officials. That's their characteristic. That is, in creating a persona different from their private ones, and the decisions thereby count as being made in our name. It is therefore the reason as determined by appropriate public officials that can explain the normative force of law and therefore its legitimacy. Legitimacy is the ability to speak in the name of all. That is the foundational normative underpinning of the legal system. Now, what I didn't have here, and I may expand a little bit in the discussion, what I didn't have here is a part in which I try to show that what Harel tried to show was, or what Harel did was, can be understood in these terms. If you look at positivist theories, you see that they identify law in terms of certain conviction or social norms that exist. Those social norms are ones that I think can be understood as approximation of the idea that the law should be made in the name of us all, because those social norms reflect certain normative convictions. So the rule of recognition and all this kind of literature that I always hated could be reconceptualized, I think, in terms of legitimacy. Thank you very much.